Like sand through the hourglass, Fani Willis is going down. The latest updates in the Fani Willis debacle, not so much dealing with who has now decided to run against Fani Willis and Scott McAfee in the latest races in Georgia. This I just have to go over because it's a thing of beauty. Jeff Clark filed a supplemental brief in response to the supplemental argument brief that was filed by the state, because what happens is after they all present their evidence and plead in the closing arguments that we watched, they submitted supplemental argument briefs to sort of supplement, to use the term in the title, or enhance or lay out, flesh out, you make something for the judge to be able to read so that he doesn't have to go back to his notes and recall everything that was argued. It's sort of a way also to try to correct some of the mistakes that you might have made in closing arguments. Abate, I'm looking at you. The state filed a supplemental argument brief, which basically sought to supplant Adam Abate's closing arguments because they were so horrid, horrible, terrible. Oh, a thing of beauty in its atrocity. Jeff Clark has filed a response to the state's supplemental argument brief, and it's a thing of beauty. I'm just going to walk you through the highlights. It's a short 10 pages. A short 10 pages meaning it's succinct, it's to the point, it's clear, and above all else, it's factually and legally well-grounded in reality. Jeff Clark, for those of you who may not know, was on the channel for a sidebar a while back. He is what Matt Damon would refer to as wicked smart. He is wicked smart. And he's obviously got an equally wicked smart attorney. They filed this supplement brief, and I'll just read you the highlights. It's glorious. It's worth going over. It's worth seeing how you plead, how you draft, and how you don't plead, and how you don't draft. Adam Abate, I'm looking at you. Come now, Jeffrey Bossert Clark, defendant in the above entitled matter, and submits this reply to the state's supplemental post-hearing brief filed March 5, 2024. In its brief, the state argues, 1, that the standard of proof should be higher than a preponderance of the evidence, 2, that an actual conflict of interest must be shown, 3, that the district attorney must be shown to have a personal pecuniary interest in conviction as distinguished from other stages of the proceedings or personal pecuniary interest in the prosecution as a general matter. Oh gosh, the kids have found me. Where was I? And 4, that defendant's evidence is insufficient to meet these standards. For the reasons set forth below, the state's arguments are without merit. For those of you who may have missed the closing arguments or the Fani Willis evidentiary hearing in general, the state's position is laughably insane. They argue that you have to show not an appearance of conflict of interest, but an actual conflict of interest. But not just an actual conflict of interest. An actual conflict of interest that is pecuniary in nature, resulting from the conviction of the prosecution itself, and that the actual conflict of interest, which is pecuniary in nature and must be in the outcome, the conviction of the prosecution, must also be proven beyond a mere preponderance of the evidence. That's the bar that the state wants to set for obvious reasons, and it's an absurd bar that I hope, for the life of me, Scott McAfee is going to appreciate. But nonetheless, that is the bar that the state argues in its post-hearing supplemental argument brief, and Jeff Clark eviscerates it point by point. Now, as a preliminary matter worth mentioning and worth highlighting in its motion, its supplemental brief, Jeff Clark argues, reminds the court that Fani Willis has persisted, not corrected Nathan Wade's patently false testimony. And in so doing, Fani Willis has effectively ratified perjury. You will recall that Nathan Wade testified to the court that he never had an affair while he was married because, as far as he was concerned, even though he was in the context of divorce proceedings, his marriage was irreparably broken as of 2015 when, he had to remind the court, Jocelyn Wade had an affair on him. He's the victim. So he never actually had an affair in the context of the marriage because his marriage was broken as of 2015, but not over in fact and in law. Hence the need for the divorce proceedings that were filed before the court. Nathan Wade lied under oath to Scott McAfee's face to the world. And Fani Willis said nothing about it not only during the hearing, ratified it not only during the hearing, but in the 3 weeks since that hearing. And Jeffrey Clark wants to start off his motion to remind the court of that. The reason for this state of affairs is obvious. It is in the district attorney's personal individual interest that Mr. Wade's perjury go uncorrected. Ms. Willis has ratified Mr. Wade's perjury by not repudiating it as her duty requires. Duty. The district attorney's professional judgment has not been merely impaired by her conflict of interest, it has been corrupted beyond redemption. It's a thing of beauty. It's like that commercial by the Church of Latter-day Saints from the late 80s. When you tell one lie, it leads to another. When you tell 2 lies, to cover for the other. When you tell 3 lies, oh brother, you're in deep. And Fani Willis, So many jokes. Fani Willis is in deep right now. She's got to cover one lie with the other. They came out there with their cash repayment of gifts, no traceability whatsoever to cover for one lie. And now she's got to cover for Nathan Wade's perjury under oath because her own butt, her own Fani, is on the line. And at page 3, Jeff Clark lays out 5 conflicts of interest, which he argues rest on undisputed facts. I think these conflicts are undeniable on their face, confirmed by the evidence, and Jeff Clark wants to go out of his way to remind the court that even if you disagree with some of these alleged conflicts of interest, they reside, they rest, they have been proven by uncontradicted facts, and here's what he has to say about that. Moreover, importantly for the purposes of this reply brief, the state makes no attempt to rebut any of the grounds of disqualification offered by Mr. Clark. 1, the district attorney's personal and political ambitions. 2, a complementary pattern of deceit and concealment of the relationship and the money. 3, the speech at the church. 4, the motion for protective order filed in Mr. Wade's divorce. And 5, and the conduct of the state's defense of the motion to disqualify. These conflicts all rest on undisputed facts. Even if the standard of proof were metaphysical certitude, it would be met as to these 5 types of conflict of interest. I had actually forgotten about, I think it's item 4 there, what Fani Willis did to Jocelyn Wade in the context of Nathan Wade's divorce. I actually forgot about that. So good on Jeff Clark for reminding us and the court. The other 4 conflicts of interest, we're familiar with those, but my goodness, he's laying it on thick. Even if it were a question of metaphysical certitude, the conflicts of interest have been proven and rest on undisputed facts. Page 4, actual conflicts. The state next argues that an actual conflict of interest is required rather than an appearance of impropriety, and that the required interest must be financial and that it must be in conviction. There are compound errors in these arguments. Jeff Clark, through his attorney, goes through this, but the bottom line is the argument is being made that it's not an actual conflict of interest that needs to be proven, but even if that were the case, that threshold has been met. It's merely an appearance, and it need not only be in a post-conviction issue, but that it relates to the process in general for reasons that are patently obvious. Page 5 at the end, the state also argues that the only interest which is disqualifying is a personal interest in conviction. This ignores that a prosecutor's statutory duty of impartiality inheres in every official act they take, not just conviction, and they go on to cite a case here. The whole proceeding from the time the case is laid down before him, where an indictment is demanded until the rendition of the verdict, is under his direction, supervision, and control, subject, of course, to certain restrictions which the law imposes. So yeah, a conflict of interest need not be pecuniary in nature and certainly need not only relate to the conviction of the prosecution. It applies at every stage of the proceedings, and it's an absurd statement to assert otherwise, and I think Scott McAfee is going to swiftly dispatch of that ridiculous argument by Adam Abate. And then Jeff Clark, via counsel, lays it on thick in terms of the actual conflict of interest here. At the end of page 7, impaired professional judgment as a result of actual conflicts. The first response of the state was the speech at the Big Bethel AME Church, in which Ms. Willis violated her public duty as a prosecutor under Rule of Professional Conduct 3.8G in order to advance her personal interests and those of Mr. Wade, an actualized conflict in which she preferred her personal interest to the detriment of her professional responsibilities. The second response was the motion for protective order she filed in Ms. Wade's divorce. In that filing, the district attorney violated Rule of Professional Conduct 3.4H by abusing the power of her office to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. You may or may not recall that in the context of Nathan Wade's divorce, Fani Willis filed a motion in which she accused Jocelyn Wade of interfering and obstructing with the Trump prosecution. From an article in the Daily Caller, quote, Jocelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in so doing is obstructing and interfering with an ongoing criminal prosecution, end quote, the motion said. Appreciate what that is. That is Fani Willis, who we now know is corrupt as the day is long, threatening Jocelyn Wade with acts of criminality, obstruction, and interference with an ongoing prosecution so as to intimidate her to stop asking questions. Quite clearly a conflict of interest, and I would dare say the most unethical conduct on earth. Her third response was the written filing on February 2, 2024 in this case, in which she stated unequivocally that there was, quote, no evidence, end quote, that she had received any financial benefit from Mr. Wade. This was false, and the state knew it was false because it came 2 weeks after Mrs. Wade filed a response to Ms. Willis's motion for protective order, attaching copies of Mr. Wade's credit card statements showing he spent over $10,000 on travel with Ms. Willis, a filing that prompted intense national news coverage that surely came to the attention of the district attorney's office. So Fani Willis comes out and says there's absolutely no evidence that she received any financial gain from Nathan Wade, knowing damn well that there would be records that show that he paid for vacations for her, and her attempt to get around that minorly inconvenient fact is to invoke that repaid him in cash argument. But even if that were the case, it wouldn't be true that there was no evidence that she benefited financially. There would be evidence that she benefited financially, but arguably reimbursed him, hence she resolved that apparent conflict. To say that there was no evidence, however, is a lie. But wait, there's more, because Fani Willis didn't only just go after Jocelyn Wade, she also accused attorney Ashley Merchant of having been a liar, having had no good faith basis to make the accusations that she made in her motion, knowing that that was false. The fourth response was to falsely accuse Mrs. Merchant of making knowingly false allegations against the district attorney and Mr. Wade. Recall, it's not just that Fani Willis said that Ashley Merchant, an attorney, was wrong. It's that she accused Ashley Merchant of having lied and having had no good faith basis to make the allegations that she made in her motion. Not only are the allegations probably 1000% true, she had a very good faith basis of making those allegations, and that was the confirmation coming from Terrence Bradley, Nathan Wade's former attorney, and Ms. Yurdi, a witness who was confirming the story. So it's not that Ashley Merchant made anything up. It's not that she even said anything that's factually false. Even if that were the case, she had a damn good faith basis to make the allegations that she made, because the information was coming from the two people who knew the most about Fani Willis and Nathan Wade's relationship. Lies, 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 and more lies. But let's get to the fifth and sixth elements and then wrap this up. The fifth response was to allow Mr. Wade to tell ridiculous lies on the stand about his false interrogatory responses and then fail to correct the perjured testimony. This was a flagrant violation of the district attorney and her entire team's duties of candor to the tribunal under the rules of professional conduct. They breached their public duties to serve the private interests of the district attorney and Mr. Wade. 6. Mr. Wade's obvious perjury remains uncorrected to this day and therefore stands as ratified by the district attorney. And then Jeff Clark concludes by saying not only does this qualify for a patent appearance of conflict of interest, that not only should they be disqualified from the case, but that the entire case should be dismissed. I don't think that Scott McAfee is going to go quite that far, but who knows? I do think, and I predicted, and I stand by it, that Scott McAfee is going to disqualify Fani Willis and Nathan Wade, appoint a district attorney from another county, and see who has not the audacity, but the absolute insanity to pursue these charges. It will be as good as dismissing the case in its entirety, but who knows? That's my prediction. That's the latest filing. It's a work of art. Jeff Clark, I'm going to try to get him back on the channel in as much as he's allowed, talking about this in real time. But if you like my stuff, you know what to do. Like, share, subscribe, hit the notification bell. Viva Frei on Rumble, Viva Frei on Twitter. If you want to support the work that we do, vivabarneslaw.locals.com. We have our massive, wonderful Law for the People Sunday night shows at 6 o'clock. We're going to talk about this and other stuff tomorrow. So tune in, and now you know your vlog. Peace out. Booyah!
Dirty.